Good morning to everyone here in Colombia, and good afternoon to all those in Europe. My name is Daniel Alejo, and I am a PhD researcher at the ERC Curabilities project, which is hosted at the Brussels School of Governance of the Free University of Brussels. The title of my presentation is The Transformation of Ecological Disputes, a closer look at actors and their roles in Latin America and the Caribbean. Before I start, I just wanted to say that as part of the organizing team, I'm very thrilled with the level of discussions that we are having during this workshop. And during these 2 days, we have seen a lot of detailed and in-depth analysis of case studies. So I wanted to present a more macro-oriented analysis of the role of factors in the transformation of ecological disputes by taking the example of Latin America and the Caribbean. I'm going to start the presentation by briefly explaining the ERC Curabilities project and the main database of transnational ecological conflicts. Then I'm going to present our work in the creation of a secondary database of the actors involved in ecological conflicts. And then I'm going to present some results that we have found from our mapping. Okay, the ERC Curabilities project is motivated by the increasing amount of legal action taking place worldwide in response to environmental degradation and injustices. The project aims to investigate the growth of litigation related to climate and ecosystem protection, often framed in human rights terms. One of the pillars of the project, or one of the main objectives of the project, is to investigate the role of social networks, actors, and courts involved in transnational ecological conflicts and the effects that litigation has on affected people, territories, and ecosystems. We focus on transnational ecological conflicts for many reasons, but one of the most important is the global scale of the climate and environmental crisis, which points to the limitations and fragmentations of the current environmental protection frameworks and governance. It also highlights the necessity to tackle environmental problems from a more holistic and comprehensive way that takes into consideration the global and the local scale. In the project, we are building a database of transnational ecological conflicts using legal and systematic content analysis to create a database of the conflicts, the actors involved, and the courts that participate in some legal proceedings. We have approximately 2,600 cases active in the period from 2000 until 2022. This doesn't mean that if a conflict started before, but it's still active in the period of these 22 years. We still consider it in our database. Here you can see some of the examples of the variables that we are using to categorize a conflict. So we have the economic activity, the economic product or commodity involved in the conflict, and the risk, the environmental risk, hazard, and harm that was at the center of the dispute or the struggle. We have been collecting data from several online databases and repositories. Some of them are the Environmental Justice Atlas, the Goldman Prize environmental website, the Transition Mineral Trackers, and many others. We have also collected data from international and regional judicial and quasi-judicial online repositories, such as the OECD National Contact Point and the Inter-American Court of Human Rights. And we have cross-checked that information with the press, with information networks such as Mongabay or Great Literature Review. I should make the disclaimer that even though we're aiming to collect data about transnational ecological conflicts, this doesn't mean that we have all transnational ecological conflicts in our database. We have many limitations, and one of them is that we're collecting data from online resources that we can find publicly available online. So this by no means means that we have all the conflicts, rather just a fraction of them. Alongside the main database of ecological conflicts, we are creating a secondary database, which actually in which we identified and categorized the actors that are involved in these conflicts. We have some of the variables that we have to categorize the actors and the role in the conflict and in the legal proceedings. You can see them in the table. So we have the type of actor, the reach of operation of the actor, the conflict role, the legal role if there was any, and if there was any legal proceeding, we have also the court name where the actor participated either as a plaintiff, as a defendant, or as a third party, amicus curiae. So a couple of weeks ago, we completed the mapping of the actors involved in cases in Latin America and the Caribbean, and we wanted to show some results of this database. And to do that, I wanted to answer who is transforming ecological conflicts into litigation in LAC, and by transforming, I mean who is bringing the cases to courts, basically who is coded as the plaintiff. And in the table, in the chart, you can see some of the results. So we have indigenous peoples and their organizations and associations were identified 136 times as the plaintiffs in litigation or complaint cases in Latin America and the Caribbean. This is the largest number in the region. However, if we combine NGOs independently of their reach, they are the largest number of active plaintiffs in the region. However, we still think that making the distinction between, for example, transnational NGOs and local NGOs is valuable for us because we can see differences in economic, financial, political, and even influential resources that each type of actor can mobilize to the case. So this is why we also have this distinction. Apart from indigenous people, we have the second largest number is by transnational NGOs, and the third one is individuals. By individuals, we mean environmental leaders, activists, and local residents without any kind of visible form of mobilization. I wanted to show this network of ecological litigation conflicts, and what you can see here in the green circles are the different type of factors involved in litigation cases in the region. And the links between the circles are the litigation cases where two actors were involved together at the same time. So the thicker the line, for example, here, the more those two actors were connected in the same or participated in the same litigation case. This network is important for two reasons. The first one is because we can see patterns of cooperation and collaboration, and the second one is because we also can see patterns of conflict. So this graph also has centrality measures, which means that the actor with most connected in the network is placed towards the center. So this is why we see indigenous peoples and their associations as the central actor in the network. It means that they participated in several cases in Latin America and the Caribbean, but they do with in collaboration with many other actors. So they have several connections with the rest of the actors. Here in the circle, we can see what I just mentioned before, patterns of cooperation, and we can see that indigenous peoples and their organizations and representatives often collaborate with transnational NGOs and with national NGOs. So this triangle actually represents a pattern of collaboration in litigation cases in the region. We can also see here, for example, a pattern of conflict between transnational NGOs and transnational corporations. So now that we have a general overview of who's triggering courts, I also wanted to answer where is this transformation taking place. So we also coded and identified the courts of the judicial and quasi-judicial mechanisms where the case or complaint was brought. And we have seen, perhaps without surprise, that national courts are the ones that are receiving the majority of litigation or complaint cases. And among them, the Brazilian National Court is actually the courts that are receiving the majority of the cases in the region. Brazilian national courts are followed by Colombian national courts. And if we stick with national courts, we can see as well Chilean, Mexico, and Argentina. I wanted to also remark the number of cases that were brought to the Inter-American Commission of Human Rights, which is actually the third largest by the number of cases received. And also in the dotted line, you can see here and here, you can see all the complaint cases that were brought or that were lodged in compliant mechanisms of international banks. And this is the compliant mechanisms of the Inter-American Development Bank, the independent consultation and investigation mechanisms. And we also can see complaints that were lodged in the compliance advisor ombudsman of the World Bank. Finally, I just wanted to show this pretty network. This actually represents all the type of factors and where they took the cases. So you can see in green the different type of factors that were involved in litigation cases, and you can see in blue the national courts that received the cases, and in purple you can see the quasi-judicial mechanisms that received the complaints. And in red, you see the Inter-American Commission of Human Rights. And with the arrows, you can see that the actor participated in litigation cases in those mechanisms. And from it, we can see clearly that indigenous peoples and their organizations participated in several cases in the Inter-American Commission, as well as national NGOs. And another point that I wanted to remark is that transnational NGOs are very active at lodging complaints in quasi-judicial mechanisms. You can see the arrows going to the purple circles. So to conclude, I wanted to give some key takeaways of who's triggering the courts after this general overview of the actors involved in litigation cases. And we can see that NGOs combined independently of their reach, either transnational, national, or local, were involved in 129 litigation cases, which is the largest amount of all type of actors in our database. Also based on our database, we have found that transnational NGOs are the largest group activating quasi-judicial mechanisms, especially the Dutch, Brazilian, and Canadian OECD national contact points. They also have very important participation in the Inter-American Commission of Human Rights. And as I have mentioned throughout my presentation, indigenous peoples and their representatives and associations are the main group bringing cases to national and regional courts, especially the Inter-American Commission of Human Rights and the Brazilian, Colombian, and Ecuadorian courts. They often do that in collaboration with other actors, as I showed in the network. They collaborated a lot with NGOs. I wanted to also remark the important grassroots mobilization that we have found in our database, coming from indigenous peoples, individuals, and local movements in the transformation of these ecological conflicts into ecological litigation. This points to the agency of local actors reacting to environmental degradation and injustices, and often using litigation as one of the strategies that they have in their repertoire of actions. And finally, I just wanted to also mention the important role of the Inter-American system of human rights in receiving the complaints connecting human rights with environmental issues, which could be an indication of the greening of the human rights, and that each one of these points will require a more in-depth analysis that we are also aiming to conduct at a certain point. But with this, I just wanted to give a general overview of our database and the role of factors in the transformation of the ecological dispute. Thank you very much, and looking forward for your questions.
Thank you very much, Daniel, for a very detailed overview of the impressive database that you have built and a flavor of what the in-depth analysis will produce. So next we have Maria Jose Luque from Ghent University, and I will share here. Are you going?
Good morning, everyone. Thank you, Cecilia, for the kind introduction. Many thanks, Liliana, for the invitation of this event. Thanks to the University of Los Andes to host it in cooperation with other academic institutions. Today, I want to present some findings of very preliminary nature about to what extent certain non-governmental actors shape the interpretation of the right to freedom of association by the Inter-American Court of Human Rights. I take the cases of Caguas Fernandez and Escalera Mejías, both brought against Honduras in the aftermath of the assassination of these two environmental defenders. This is one of the line of jurisprudence that I investigate in my project, NGO Steer, the Inter-American Court of Human Rights, founded by the Horizon 2020 program of the European Union. So to this end, I divided my presentation into 4 main parts. First, I will briefly identify who were the actors that intervened in both cases, either as representatives of the victims or as third parties that submitted an amicus curiae brief. Then I briefly outlined the procedural history of selected cases. I consider this is essential to do because the cases are interconnected, have a lot of particularities, complexities, but also already allow us to identify how this influence and the normative outcome in the court evolve. Then I briefly map, because of the time, briefly map on which aspects of the court interpretation of this right these non-governmental actors were able to steer. And for that, I briefly take, for instance, on which legal basis they encourage the court to interpret this norm in a certain way, which type, how they understood the normative content, and also how they understood which were the state conducts, the conducts of Honduras that violate the right of these environmental defenders. And finally, I conclude briefly with what I think was the influence of these actors in both cases. So moving into my first point, the victims in Caguas Fernandez and Escalera Mejía were represented by Sehil and Eric. Sehil is a very well-known regional NGO that is very active in terms of advocacy and also in terms of legal representations before the Inter-American human rights system. They usually, when it comes to legal representation, always works in alliance with another local NGO, and this is the case of Eric. It's perform activities of advocacy and research to promote and protect human rights in Honduras. It's an Honduran NGO. Certainly, these two actors are the main actors that shape the interpretation of the court. However, that being said, there were other third parties that intervened with their amicus curiae, and they also may have also inspired the court in both cases. There were, in Caguas Fernandez, for instance, was Environmental Defender Law Center, while in Escalera Mejías, there were 4 actors that intervened. The common feature among all these non-governmental actors is their non-Honduran origin. And in terms of NGOs, we can say that all are based either in the US or they have offices in Europe. In addition, only one have experience in legal representation, while most of them are more active in advocacy and research, and in this way, with this experience, try to underpin the litigation strategies of Sehil and Eric. Interestingly also, there were 3 actors that has as their special focus of their work the protection of human rights or environmental defenders. But With this overview, however, it's also interesting to have a kind of overview on how the protection mandate of the Inter-American human rights system works in order to have a better grasp of the interactions and on the moments when these people intervene. So this leads me to the second point of my presentation, but first, how it works, the Inter-American human rights system. So victims face, unfortunately, violations of their human rights and usually have to resort to the domestic courts. Once they have exhausted the remedies there, then they submit a petition to the Inter-American Commission of Human Rights. The Commission is the gatekeeper of the system. They really filter which petitions reach the court. And how do they do, how the Commission does that? Well, they apply very strict legal criteria in order to determine if the petition is admissible, then if it had merit, and if it merits the establishment of the breaches, and accompanied by recommendations for the state involved. If the respondent state in that case then have three options. It follow the recommendations, or reach an amicable agreement with the victims, representatives of the victims themselves, or most of the case, they don't follow the recommendations, and after one period of time, the Commission decides to bring the case to the Inter-American Court. So with this background, allow me to explain what it comes next. How these two cases differ. Caguas Fernandez and Honduras was a case brought by the Commission in February 2008, and the Commission only established a violation of the right to life. However, in the initial stage, Sahil and Eric not only were of the view that a violation of the right to life was occurred, but also a violation of the right to freedom of association. Honduras, however, when in its statement of defense, challenged the contentions that his actions or omissions breached the Caguas Fernandez right to life. However, in the middle stage, where the public hearings, the parties intervene and participate, the disputing parties, the victims, the state, Honduras, exchange their views. But at the last stage, before the court rendered the judgment, intervened the Environmental Defender Law Center that I mentioned in the first part of this presentation. And they argue that they were of the view that in this case, Honduras all violated their rights to freedom of expression and association, based on a timid reference of the so-called right to defend human rights. However, when reading the amicus curiae brief that this NGO submitted, they did not elaborate. They did not subsume the conduct with the rule. Rather, they only state what was all the legal basis and how the codification of those rights. However, at the end, the NGOs, Sahil and Eric, did shape the court, because in the judgment, the court aligned with the view of the representative of the victims of Caguas Fernandez. Then almost 9 years later of the judgment in Caguas Fernandez, the Commission again submitted a case against Honduras in December 2017. But before that, there were a lot of exchange between the parties. This case, again, Sahil and Eric represented Escalera Mejías and his family. And there was a lot of interaction at the stage of the Commission. Why was that? The Commission issued recommendations and established violation of the rights to life, but also an association. I presume that the outcome in Caguas Fernandez informed the decision and understanding of the rights of the Escaleras Mejías and of the environmental defender. Then 1 year later, Honduras notified that it reached an agreement with Escalera Mejía and the representative. However, it challenged again that his conducts or omissions were amounted to a violation of the rights of Escalera Mejías. And in that agreement, Honduras, for instance, committed to some reparations, for instance, to make a documentary in favor of Escalera Mejías, name a national park in his honor, and so on. But the Commission identified that still the criminal investigations were insufficient, were not appropriate, and for that reason, it submitted again another case against Honduras for similar facts. Then Sahil and Eric, as representative in this case of Escalera Mejías, again, this time claim a violation of an autonomous right to defend human rights, understanding this right as comprising the right to freedom of expression and association. But some months later, Honduras, in its statement of defense, already recognized the breaches of these of the rights as the Commission understood them, not as the victims understood it. And some weeks later, it also include and communicate the court that it reached an amicable agreement with Escalera Mejías and their representatives, in which, among others, and I find this very interesting, is that where the parties requested the court to develop the right to defend human rights. I mean, that was, again, the trade-off. It seems that it has been the trade-off of Honduras. And understanding this right as comprising only the right to life and the freedom of association, leaving aside the pretension of the victim representative that also, in a previous months before, pleaded for freedom of expression. And so at the end, at the middle stage, then Honduras requested homologation of the agreement, and it was in this stage that the other four amicus curiae submissions were presented, and the judgment concluded in this aspect. Since the time is very short, I will pass a bit my third part, because I can conclude with the last one. I mean, how these let's say how these actors influence the court. What I see from the jurisprudence for concepts such as when understanding and reading how the court understood the right to life, and then in connection that this right give rise to a breach also to the right to freedom of association. The non-governmental actors, representative especially of the victims, were very successful and achieved to anchor the notion of interdependence of rights in order to establish breaches and of the rights established in the American Convention. However, in Escalera Mejías versus Honduras, we see that the formulation of the violation of the understanding, better said, of the right to freedom of association is different. It's understood as an element of the right to defend human rights, based on the notion of interdependence already, but framed in line with the UN Defenders Declaration that was released in 1998. So this is the difference and the impact of the influence of those actors on the court. First, the notion of interdependence of rights, and afterwards, okay, interdependence of rights, but at the very big framework of all this interdependency, it's called the right to defend human rights. With this, I thank you for your attention, and I'm really looking forward for your comments and suggestions. Thank you.
Thank you very much, Maria Jose, for this very detailed analysis of a fascinating case. Now we're going to move to an online presentation by Carlota Garofalo. She is based at the University of Graz in Austria at the Institute of Public Law and Political Sciences. So, Carlota, if you like to share your slides, or
yes, I will share my slides. Just a second. Could you let me know if you can see it properly?
not yet.
Not yet. Okay. Can you see my screen though?
No.
Okay, I just stopped sharing. Okay, just a second. I'm sorry. Okay, so it seems that there are some.
Hi, Carlota, please stop sharing it and share it again.
I think it has to do with my Google Chrome setting. Maybe I could share it with you, otherwise just in the chat and you can share it. Or I'll just try one more time.
Try one more time and you can share it in the chat.
Yeah, maybe it's a bit easier if I share them in the chat.
Okay, no problem.
I have an online version, otherwise I have the PDF, whichever works better for you.
Okay, I'm going to share my screen.
Okay, thank you. Okay, great, thank you. So first of all, sorry about this. There's always a bit of technological in presentations, but thank you for your help in this. So yes, I am a PhD student at the University of Graz in Austria, and today I'd like to present with you a chapter of my thesis that is about climate litigation, the climate litigation movement in Latin America. So next slide, please. So the overarching research question of the chapter is how do lawyers and social movements use and shape climate litigation in Latin America? And more precisely, the questions are why do these actors turn to litigation, to climate litigation in the first place? How do they do so? With what methods? With what purposes? And finally, what are the implications of the way they use litigation for the overall climate litigation movement? So I'll start providing some context. It's okay. I'll start providing some context of the literature and also the socio-political context in which climate litigation happens in South America, and I'll then illustrate my findings and my conclusion. So in terms of the motivation, this is practically superfluous in this panel because we are all looking at social actors and we are all looking at global actors, but you probably share the view that climate litigation research up until now has mostly focused on global north cases, mostly from a legal perspective, and also that the kind of cases tend to be high-profile climate lawsuits, so filed before high courts for aiming for structural changes. And this tends to create a bit of a bias or a perception that all climate change litigation is strategic litigation. Next slide, please. But what I wanted to do is also to look a bit more freely at what climate change litigation is in South America, and trying to see whether strategic litigation really captures the overall phenomenon of climate litigation in the continent. Then, as I will explain, I've not really looked at all the countries in South America, but I've selected 4 of them. In terms of what strategic litigation is, it is generally defined as a form of litigation or a tool that is used by NGOs, human rights activists, and lawyers to pursue goals that go beyond the immediate interest of the parties involved in the case. And these goals can be really of different nature, legal, but also cultural and political. Also, strategic litigation is the process of identifying, selecting, and initiating cases due to their potential impact to provide integral solutions to social problems. This definition by Montoya. Regarding its origins, strategic litigation is indeed a legal tool that originates in the US in the public interest law movement, but then spreads globally and also in Latin America, mostly starting from the 2000s and the 2010s in some specific countries, depending on the funding, on the international funding. On the other hand, in the next slide, we can see that, could you turn to the next slide? Thank you. We can see that strategic litigation is not the only way in which lawyers and social movements have turned to have used legal mobilization for social goals in the continent. And an important one is people's lawyering, abogacía popular, a form of lawyering that developed actually much before the arrival of strategic litigation in the continent, or at least its diffusion in the continent. So people's lawyering starts already in the 60s, in the 70s, in some countries like Argentina and Brazil during military dictatorship, as a way for lawyers to defend political opponents, political minorities, but then they also extend to defend other minorities, ethnic minorities, vulnerable people, poor neighborhood-based collectives, and also, lastly, environmental collectives. So in general, environmental lawyering is an alternative form of lawyering that aims to break the barrier between the idea of a lawyer as an expert and his or her clients. The lawyer, the people's lawyer, is a militant, is an activist, or is at least connected to the social movement that he or she assists. Also, normally, people's lawyer have a Marxist or a critical view of the law, so they see it as a subsidiary tool to politics. And they tend to be also politically mobilized, not only legally mobilized or participatory to the political activities of the movement. And in terms of the litigation and the strategy, they create or they form the legal strategy in community or in consultation with the affected community in a rather horizontal way. We can skip the next slide, I think, and go to the, skip this slide and go to the next one. Then, as you can imagine, the practice is always more complex than the theory, so the distinctions are not as neat in practice as they are in theory. And scholars, Latin American scholars, have also talked about the translocalization of strategic litigation. This big and difficult word has to do with what happens when a legal model or a legal construct is globalized, such as strategic litigation. So it is the process through which a legal construct adapts to a legal context, to a local context, to the local processes, actors, practices, and it's not always a very linear process, but also can entail resistance, selective appropriation, or subversion of foreign norms and institutions by locals. And this is also what happened to strategic litigation when it reached South America. and Latin America. We have really the example of legal clinics using more horizontal, more collaborative methods that are normally those that would be typical of people's lawyering, but to file strategic cases. And also we have an increasing trend of people's lawyering talking about their litigation efforts as strategic litigation. Could you go to the next slide, please? So what I did with this chapter, besides the literature review, was to try and understand what are the motivations, the methods, and the vision of climate litigators in South America. I focus on Argentina, Colombia, Brazil, and Mexico as countries with more cases and also with more greenhouse gas emissions, even though this is very, very low compared to North American and European states. So I did a thematic analysis of 12 semi-structured interviews. Also, I tried to differentiate in relevant variables. So I interviewed lawyers that filed low-profile cases, so territorial cases in administrative courts, and lawyers who filed instead high-profile cases. Also, lawyers who assisted larger and specialized non-governmental organizations versus lawyers that assisted grassroots organizations. Also, what happened, as some of you also mentioned, is that mostly grassroots organizations collaborated with regional and national NGOs. So this also adds a layer of complexity to the analysis, of course. In terms of the finding, we can go to the next slide, please. So when it comes to the motivation and goals, indeed, lawyers assisting NGOs in high-profile lawsuits were distinguished in their motivation from lawyers assisting NGOs and grassroots organizations in low-profile cases. So the former tended to frame their motivation, their engagement with climate cases in terms of their professional or academic background, whereas the latter rather highlighted their ideological or political motivations. Strategic litigators or lawyers engaged with high-profile lawsuits, especially in Brazil during the Bolsonaro mandate, highlighted the political necessity to use litigation, whereas people's lawyers in other countries highlighted the material necessity of specific communities that had reached out to them. Also, it was different, or the two types of lawyers, like to simplify a bit, differed in how they framed their goals. Strategic litigators or lawyers that tended towards that type frame their goals as legal and policy centered, so creating legal precedent, stopping the policy regression, whereas people's lawyer really frame their goals referring to the community, so the intent to benefit the community, to stop a harmful project, to visibilize harms, and so on. The biggest difference was, though, in the methods used by two different lawyers or legal collectives. In the next slide, we can see. Can we go to the next slide? We can see the difference really in the methods. So lawyers filing high-profile cases were preoccupied about selecting plaintiffs that would be representative of a case or of an idea. With regard to the legal strategy, they looked for a legal strategy that fit with a certain narrative and with a certain organization's overall strategy or agenda. In terms of the plaintiffs' engagement, plaintiffs were not really engaged so much in the legal strategy, but they were really important, for example, in many cases, in the youth-led cases, especially in the campaigning moment, and also in a case we will see now for the after judicial decision. Cases filed by grassroots organizations, lawyers did not really have to select the plaintiffs because the plaintiffs reached out directly to them. Often they already knew each other, were in contact, were part of the same movement. The main preoccupation here in the legal strategy was to really reflect the community's values and views with the legal argumentation, and that therefore the plaintiffs were actually engaged in the construction of the legal strategy, besides in the outreach and other moments. And also, as said, they were involved in the political business. We have an example of two cases. And could you turn to the next slide? Okay. I hope you can hear me well, because I see I don't have a very stable connection. But an example of these two type of cases is in the comparison between the Future Generations case in Colombia and the Bruno River case in also in Colombia. I see that I'm going maybe too long, so I will try to be a little quick. In the Future Generation case, we have a typical strategic case because we have an NGO that is selecting a young plaintiff to bring a case that is about the rights of future generations, and where the plaintiffs are involved in the campaign and in the monitoring of the case's implementation. Whereas in the Bruno River case, we have an indigenous community that is affected by an action from a coal mining company, and here the preoccupation of lawyers is to really to bring the attention of the court to the fact that the diversion of a river will affect the community, not only fundamental rights, but also their cosmovision, their worldview. So there is indeed a process of involving actively the community in the legal strategy of the case to make sure they are benefited at the end of the case by the judicial decision. I have two more slides. In the next slide, we can see that there were some convergences at the end of the day between strategic litigation and people's lawyers in how they saw the cases and their role in creating social change. So strategic litigators were not always hopeful of the court's of the case's effectiveness in creating social change, but they thought that it would be an important instrument to empower movements and activists. On the other hand, people's lawyers really emphasized that the case was just one part of a much larger political mobilization process, and that it had the function to support that political process. But on the other hand, in some cases, people's lawyers were more hopeful of the case's potential to create institutional change. There were also some difference in the risks that they found. People's lawyers, for example, really highlighted that strategic litigation, but in general litigation, can also have risks such as demobilizing movements and also imposing foreign legal tools and legal narratives. And then going to the conclusion, in the final slide, in the next slide. In conclusion, I found out that I find that the climate litigation movement moves to some extent in continuity with the global or the northern climate movements. There are similar trends, for example, an increasing trend to file central high-profile climate cases, also specialized NGOs and also public and sublocal authorities are the main actors of rights-based, at least the climate cases in the countries that I have selected. There is also a tendency to translocalize grassroots organizations, where about 1/5 of the actors filing rights-based cases, so they are still very much involved. As it was noticed, also they often act in alliance with regional NGOs, national NGOs. And what is also interesting is that when they are filing cases that have a more structural or strategic nature, they do so with different methods, so with more bottom-up approaches. So at the end of the day, strategic litigators and people's lawyers are not really two essentially different kinds of lawyers. Of course, there are different methods and different visions involved, but there is also an increasing trend for people's lawyers to appropriate strategic litigation and to use it, at least in the climate context. And this appropriation, I would conclude, is also a positive one. I didn't have the chance to show many cases today, but there are some quite interesting cases where we see that the climate litigation coming from more bottom-up processes also has this potential to bring together local and global struggles and unite different social actors. in a common cause. So with this, I conclude and apologize again for the technological inconvenience and look forward to your questions.
And on a multi-scale analysis, moving from the regional to the specific, and showing us the motivations and risks associated to litigation. And I see already some possibilities for exchange of findings between your findings and Curiability's project. So now we moved to Carla Feinstein from Universidad Nacional General Sarmiento and Consejo Nacional de Investigaciones Científicas y Técnicas de Argentina. Oh, okay. Carla is not here, so we're going to have some time for questions and discussion. So if you want to come up to the stage. Ella sí está aquí. Carla, you're here, yes? Okay. Roger, could you please allow Carla to present? Yeah.
Hola, profe, Carla no está conectada.
She's connected with as Daniel.
Ah, ok, Daniel Alejo.
Daniel Alejo. Está conectada como Daniel Alejo.
Listo.
Hola, ¿me escuchan?
Sí, te escuchamos.
Ay, disculpe. Tuve un problema de diferencia horaria y después Daniel me pasó este link para poder presentar.
Está bien, Carla. Genial que te hayas podido conectar.
¿Puedo compartir mi presentación desde aquí?
Sí. Adelante.
Ahí ya creo que deberían estar viendo mi pantalla.
Sí, ya.
Perfecto. Ahí va. Bueno, nuevamente les pido mil disculpas por el retraso y la entrada un poco accidentada. La diferencia horaria me jugó una mala pasada. Y bueno, muchas gracias por aceptar mi trabajo en el workshop. Voy a presentar un trabajo de investigación que tiene que ver con algunos resultados de mi tesis doctoral y del trabajo que estoy empezando ahora. Tiene que ver con pensar en los efectos sociales de un litigio ecológico estructural en el área metropolitana de Buenos Aires, pensar un poco en los actores, en la acción colectiva y las representaciones sociales que se ponen en juego en asentamientos informales de la cuenca Matanza-Riachuelo, que es una de las cuencas que atraviesa el área metropolitana. Bueno, yo soy de formación de base socióloga, así que bueno, estaba escuchando que hay muchos trabajos que vienen más del campo del derecho, así que bueno, es una mirada centrada además en un caso más específico. Y bueno, como les decía, es trabajar un poco en los efectos, ¿no? del después de la sentencia judicial. Para ir muy rápido, en primer lugar, presentar un poco el caso en términos generales. Se trata de una mega causa estructural que en la Argentina es un ejemplo en términos de litigio de derechos ambientales, por la envergadura que tuvo, por los actores que estuvieron involucrados, tanto del Poder Judicial como después del Poder Ejecutivo y actores sociales en este proceso. Bueno, ya tiene 15 años la sentencia de este juicio, un poco para hacer el recorrido de este litigio. En el 2004, un grupo pequeño de demandantes de algunos barrios populares y algunas asociaciones barriales que estaban dentro de la cuenca presentan una demanda por daños ambientales y en el 2006 la Corte Suprema de Justicia de la Argentina declara su competencia en la causa. En simultáneo, por ley, se crea la Autoridad de Cuenca Matanza-Riachuelo, que tiene estatus, funciona a nivel nacional, lo cual es particular en la Argentina porque es en general una competencia de las provincias. Así que esto es algo único, digamos, en términos institucionales. Y en el 2008 la Corte declara falla en el caso y sentencia a los demandados, que eran el Estado Nacional, el Estado de la Provincia de Buenos Aires y el gobierno de la Ciudad de Buenos Aires y 44 empresas privadas, a una serie de demandas cuyos objetivos principales deben ser el saneamiento del daño ambiental en la cuenca del Matanza-Riachuelo, la prevención de daños futuros y la mejora de la calidad de vida de la población de ese territorio, lo cual debe estar regido por un plan integral de saneamiento que le ordena al Poder Ejecutivo que elabore en conjunto, que es un programa que, hay un proceso judicial de discusión, de debate, de audiencias, y en el 2010 se aprueba ese plan definitivo que en el 2016 se actualiza nuevamente, ¿no? O sea, es un proceso que ya lleva 16 años, el del cumplimiento de la sentencia. Y por otra parte, esto crea una estructura en términos judiciales como muy novedosa y específica, que tiene sus propias particularidades, que no son lo que voy a trabajar acá, pero que es muy interesante. Y dentro de este esquema que arma la Corte Suprema para la ejecución de la sentencia, nombra a jueces de primera instancia del fuero penal para que sean los que controlen, acá había hecho un esquemita de actores, para que controlen la ejecución de la causa, ¿no? O sea, y a lo largo de los años, de hecho, lo que se ve es que la Corte Suprema se retira un poco en su actuación dentro de esta causa. Entonces, una de las particularidades de los conflictos que se suceden luego de la sentencia, ¿no? Porque mi eje es esto, como trabajar qué es lo que sucede después de la sentencia, ¿no? No la sentencia como la culminación del proceso o el fin, el cierre, sino el inicio de otra serie de procesos y de una gran serie de conflictos en la implementación de las políticas ordenadas por este litigio. Y en ese proceso tenemos toda esta serie de actores, ¿no? La Corte Suprema, como bien decía, los juzgados de primera instancia, las defensorías y las fiscalías, tanto las que responden a la Corte como las que responden a los juzgados federales de primera instancia. Después está el cuerpo colegiado, que es un organismo que crea la Corte dentro de esta causa, que debía ser coordinada por el Defensor del Pueblo de la Nación, que es un cargo que en la Argentina está vacante hace más o menos 9 años, que estaba conformado por un grupo muy reducido de organizaciones, ONGs, que tenían, que es el lugar que se le adjudica en la causa a la participación, ¿no? De los afectados, digamos. Pero por otro lado, yo acá ponía a los habitantes de la cuenca como por fuera, porque lo que sucede, lo que también da su especificidad a este litigio, es que es un litigio que comienza con una demanda de un grupo pequeño, que afecta a un territorio muy vasto, que ahora voy a mostrar un poquito más, y que termina afectando a millones de personas, ¿no? Que no tuvieron ninguna incidencia en el motorizar esta herramienta, o sea, en ir por la vía legal, digamos. Y por otro lado, todos los organismos del Poder Ejecutivo que están involucrados que son los demandados, ¿no? Que están involucrados en el cumplimiento de la sentencia. Muy brevemente, acá se ve el área metropolitana de Buenos Aires, la cuenca, que es la que está, marcada están los distritos en su conjunto que están en la cuenca y después la cuenca hídrica marcada. Después, de nuevo, muy brevemente, para hablar un poco de qué es lo que sucede en esta cuenca, la serie de problemas ambientales que la quejan, digamos. No sé si me están diciendo algo porque no puedo ver si hay un comentario, pero bueno. Como les decía, la cuenca tiene alrededor de casi 5 millones de habitantes, es una de las más contaminadas en el país, o la más contaminada, sobre todo por contaminación vinculada con efluentes industriales, pero también en la cuenca alta, que es una zona más bien rural, relacionada con contaminación por agrotóxicos, con las modificaciones en el ambiente que genera el crecimiento de desarrollos inmobiliarios que afectan los humedales que hay en esos territorios, ¿no? Toda esta zona es zona de humedal. Por otro lado, numerosos basurales a cielo abierto ilegales que hay a lo largo de la cuenca, los problemas más serios tienen que ver con el vertido de residuos sólidos urbanos dentro de estos ríos, que tiene que ver con los déficits en infraestructura de cloacas y de agua, de redes de agua, de pluviales que hay en este territorio. Y bueno, además, el que la ciudad, ¿no? El área metropolitana de Buenos Aires se extiende sobre este territorio de manera no planificada en términos urbanos, y es un territorio, como les decía, de humedales, inundable, lo cual genera también toda otra serie de problemáticas más relacionadas con esto, ¿no? Con inundaciones, bueno. Y por otro lado, presentar esto, ¿no? Yo además, aclaro, vengo del campo de los estudios urbanos, y intento un poco articular, articulo con la sociología ambiental, etc. Hay una sobreocupación de las costas, de los territorios más vulnerables en términos ambientales, por asentamientos informales, de barrios populares también, les están llamando últimamente en Argentina, que son barrios que presentan déficits aún más graves en términos de infraestructura, esto de acceso a servicios, de calidad de la vivienda, de precariedad en la tenencia del suelo, y bueno, se localizan en lugares además que son los más vulnerables ambientalmente, o próximos a industrias, por ejemplo. Y bueno, un dato que no está del todo actualizado, pero que teníamos, es que en la cuenca tenemos más o menos un 30% de la población que habita en asentamientos informales, mientras que si tomamos el resto del área metropolitana, ese número está más o menos en un 10%, ¿no? Esto era un poco, muy brevemente, para mostrar las coberturas. Esto es la actual, igual, no es con la que se encontró la Corte cuando comienza la causa. Y bueno, en este paneo general, en el que fui muy rápido, cualquier cosa luego me pueden consultar, yo trabajé sobre algunos asentamientos informales que quedan en la cuenca baja, que esto es importante también porque es bastante heterogénea el territorio de la cuenca. La cuenca baja es la zona más es como el centro de la metrópoli, ¿no? Acá está la ciudad de Buenos Aires, es un territorio muy densamente poblado y urbanizado, donde también hay gran concentración de industrias, los que la autoridad de Cuenca llama agentes contaminantes, que bueno, es un área distinta de lo que puede ser la cuenca media o alta, donde también hay otras problemáticas, y es otro el territorio, ¿no? O sea, tenemos situaciones más de áreas urbanas o zonas mixtas. Esta área es como eso, está muy densamente urbanizada, estos asentamientos son bastante antiguos, tienen otras características. Yo trabajé sobre estos 4, la Villa 21-24, Villa Jardín, el Campo Unamuno y Campo Mar, que son asentamientos que quedan uno en la ciudad de Buenos Aires y los otros en distintos partidos de la provincia de Buenos Aires. Que yo trabajé sobre esto, no voy a entrar tanto en los detalles en esta presentación, pero elegí que sean en distintos distritos, porque uno de los temas de este litigio es que se aplica sobre justamente diferentes jurisdicciones, con diferentes capacidades institucionales, con diferentes competencias, que llevaron adelante las políticas que ordena la Corte Suprema de diversa manera, y esto hizo que los procesos tengan sus diferencias, ¿no? Pero bueno, acá voy a plantearlas más en términos generales. Yo trabajo desde las perspectivas de Patrice Melé, Antonio Suelo de la Cueva, que piensan en la productividad de los conflictos, ¿no? En los efectos de distintas dimensiones que pueden traer estos conflictos. Y en ese sentido, acá voy a presentar muy brevemente algunos efectos, muy brevemente, porque además ya estoy viendo el tiempo, algunos efectos institucionales, sociales, simbólicos que trajeron aparejadas las políticas que ordena la Corte, ¿no? Que ordena este litigio. Y en términos generales decir que las políticas que se aplican en estos barrios a partir de la causa Mendoza, que se le llama por la carátula, tuvieron que ver con principalmente políticas de urbanización de asentamientos, políticas de relocalización de la ribera del río principal y de sus afluentes, y otras políticas de salud ambiental, educación ambiental, obras de infraestructura, pero que bueno, una de las cuestiones es que no están hay unos problemas en la articulación entre esas políticas, ¿no? Lo que hace que corran como por distintos carriles. De hecho, hay legajos dentro de la causa principal donde esto está todo fragmentado, ¿no? Entonces, bueno, eso le trae otras dificultades para los habitantes. Pero bueno, esto, para ir muy brevemente, en términos de efectos institucionales, que tiene que ver con pensar en los nuevos arreglos, los nuevos espacios dentro de las instituciones que se generan a partir de esta sentencia, y también de la apertura de espacios de participación, tenemos lo que se vio a lo largo de estos años es el crecimiento de las burocracias, tanto dentro del Poder Judicial como dentro de los distintos niveles del Poder Ejecutivo, en torno a la causa Mendoza, ¿no? Y a la cuestión ambiental, digamos. Se vio, por ejemplo, en los municipios la creación de oficinas, secretarías, direcciones de ambiente, donde antes no las había, la creación dentro de los organismos judiciales, de las defensorías, de la Procuración General, mismo de los juzgados, de áreas específicas para tratar este tema, y no los temas ambientales en general, sino los que tienen que ver con esta causa. Equipos especializados en el riachuelo, digamos. Además, obviamente, de la creación de la CUMAR en general, ¿no? De la Autoridad de Cuenca. Y también acá, entonces, la incorporación de nuevos aprendizajes, de la incorporación de saberes técnicos de otras disciplinas a estos equipos del Poder Judicial y también del Poder Ejecutivo en sus diferentes niveles, que visibilizan el debate ambiental, pero bueno, adelantándome un poco a las conclusiones por el tiempo, que no terminan de asentarse. Bueno, de hecho, entre paréntesis, nosotros tenemos un nuevo presidente que dice no creer en la existencia del cambio climático, con lo cual todo esto que yo les puedo explicar tiene todo ese nuevo matiz, pero logra una instalación de la cuestión ambiental, sobre todo en términos de la necesidad de abordarlos desde una perspectiva interjurisdiccional, integral, etcétera. Pero, por ejemplo, lo que vemos es que este ejemplo que podría haber sido este modelo no se replicó para ninguna otra cuenca o para ningún otro caso. Bien, y en términos de participación, que es uno de los problemas más fuertes de este litigio, que es que no hay un espacio pensado para que los habitantes sean parte de la causa en términos legales, sí se abrieron en el ámbito de la política pública espacios de participación con muchas dificultades y problemas, pero que han funcionado como mesas de trabajo. Y después lo que más ha servido como posibilidad de participar para los habitantes ha sido el accionar de las defensorías de la Nación, del Ministerio Público, de la Defensa y de la Procuración General, que han tenido un trabajo de abordaje territorial fuerte por las características de los abogados que allí trabajan, por la característica de estas instituciones en la Argentina, que han llevado a través en la estrategia legal la voz de estos habitantes. Que, bueno, perdón por la velocidad. Y en este sentido, esto último que estaba diciendo, lo que vi en los distintos barrios es que un poco lo decía justamente la compañera que antes presentó su trabajo, que la estrategia legal en algunos barrios cobra mayor centralidad y se constituye en la forma de acción colectiva o en la estrategia central para los vecinos, para las organizaciones de los barrios, pero en otros casos constituye una estrategia, ¿no?, más entre otras, que son las más tradicionales de las organizaciones sociales de asentamientos informales en la Argentina. Y bueno, en términos justamente de efectos sociales, podemos ver algunos efectos en algunos barrios en los que la irrupción de este litigio y de las políticas que son producto de este litigio tendieron a consolidar organizaciones preexistentes, ¿no? y a unirse en torno de todas estas nuevas políticas que surgen a partir del litigio, lo cual no sucede en los barrios que no estaban afectados por esta causa. ¿no? Como una oportunidad, y por otro lado también la fragmentación, en barrios en los que una parte del barrio está afectado y otra no, sucede la creación de nuevas organizaciones que solo disputan dentro de esta causa judicial, perdón, o las políticas que supone esta causa judicial. Entonces vemos así muy genéricamente, estas dos posibilidades, ¿no? La consolidación o la fragmentación de las organizaciones. No fue ni una ni la otra. Creo, perdón, que estoy... Hola, ¿me escuchan?
Carla, porfa.
Sí, que estoy pasada de tiempo, ¿no?
Sí.
Bien, bueno, después no continúo, para mí está bien cerrar por aquí, pero solo decir que también hay una serie de efectos simbólicos, ¿no? Y territoriales que traen aparejadas las políticas y la existencia de este litigio en estos barrios informales que tienen que ver con el repensar la cuestión ambiental, el visibilizarla, el llevar adelante estrategias que tienen que ver con este derecho, con el acceso al ambiente sano, y esto lo destaco porque porque en la Argentina los movimientos arraigados en asentamientos informales tienen una tradición de lucha que está centralmente relacionada con el acceso a la vivienda y al suelo, y no al ambiente, digamos, o a la lucha contra la contaminación, ni hablar de las discusiones en relación al cambio climático, y sí bien algunos de estos barrios en los que trabajé que se inician algunas acciones de estas organizaciones relacionadas con ese tipo de discursos y con esas narrativas que me parece que es muy interesante y que tienen que ver con la existencia de este litigio, ¿no? Y que es muy particular esto, ¿no? Para los sectores pobres urbanos en la Argentina. Pero bueno, dejo acá esto por cuestión de tiempo. Les pido disculpas y muchas gracias por...
Gracias a ti, Carla. Muchas gracias. Bueno, entonces vamos a darle paso al diálogo, al debate. Entonces, los que estén online pueden escribirnos sus preguntas al chat o alzar la mano para darles la palabra. Y acá en el público también, si hay alguna pregunta, aquí tenemos una para Daniel. ¿Han podido estudiar la efectividad y decisiones enmarcadas en los litigios ecológicos que han mapeado? Mientras los demás se animan, vamos a esa pregunta.
Bueno, muchas gracias por esa pregunta. En efecto, ese es uno de los pilares del proyecto, ese es uno de los trabajos que estamos realizando. También vamos a crear una base de datos con los tipos de remedios, con los tipos de decisiones judiciales si hubieron. Así que eso es parte del trabajo, pero hasta el momento no lo tenemos. Hasta el momento solamente estamos mapeando los conflictos y los actores que están envueltos en esos conflictos. Pero definitivamente es parte del trabajo que vamos a hacer.
Muchas gracias. Un momento que ya nos...
Muchas gracias, buenos días. Camilo Ramos desde Bogotá, Colombia. 3 inquietudes muy puntuales para Daniel Alejo. ¿Cuál es su opinión sobre la conflictividad ambiental, el litigio ecológico y el desplazamiento climático en países muy puntuales, por los países insulares del Caribe? ¿Cree que por su vulneración y por su alta exposición al riesgo del cambio climático se enfrenta, por tanto, una litigiosidad ambiental más pronunciada? Solamente los países insulares y los países ribereños del Caribe. En segundo lugar, para la doctora María José Luque, ¿cuál es su opinión de que Venezuela se haya retirado del sistema interamericano de derechos humanos y que Estados Unidos no reconozca la competencia contenciosa de la Corte Interamericana? ¿Esto afecta en cierta medida la litigiosidad transnacional en materia ambiental? Y por último, para Carla, desde Argentina, cómo afecta el negacionismo oficial del actual presidente de Argentina del cambio climático la tarea de del litigio ambiental en ese país. Muchísimas gracias.
Gracias, Camilo. Adelante, Diana.
Bueno, muchas gracias. Muy súper interesantes todas las presentaciones. Yo tengo más que preguntas como comentarios y saber si quisieran reaccionar a ellos. En el caso de los hallazgos alrededor de la base de datos, me parece muy interesante encontrar que el mayor número de casos sea de pueblos indígenas y sobre todo dirigidos en América Latina al sistema interamericano, cuando lo cierto es que muchos casos de pueblos indígenas que fueron fundantes en el sistema, ya cuando se devuelve el cumplimiento en el plano nacional, pues resulta que no se cumplen, ¿no? El caso trágico, digamos, por ejemplo, de Paraguay, con 2 o 3 casos muy importantes, algunos de ellos que tienen que ver con devolución de los pueblos indígenas a sus territorios, y simplemente desde la sentencia que ya llevan 20 años no se han cumplido. Entonces hay como siguen los pueblos indígenas litigando ante el sistema, pero se pueden crear estándares, sí, que es un poco lo que conecta con la presentación de Carlota, pero no hay transformaciones sustanciales en el sistema y sin embargo siguen estando allí. Entonces eso me llama la atención, simplemente un comentario sobre eso. Y esto conecta justamente con lo de María José, y es el tema del litigio en Honduras respecto de 2 defensores ambientales, pero también en un contexto en el cual es en Honduras donde se produce el asesinato de Berta Cáceres, y es en Honduras donde se siguen produciendo casos sobre la población garífuna, que también tiene reivindicaciones en relación con su territorio y el medio ambiente, y sigue habiendo un estado de absoluta impunidad y en relación con personas defensoras ambientales. Entonces están esas sentencias, sí, y de hecho ya la Corte con el caso colectivo de abogados versus Colombia reconoce el derecho autónomo a la defensa de derechos, pero sigue habiendo, digamos, esos ataques y demás. Entonces pareciera como que el sistema es más para generar estándares que para hacer transformaciones internas reales y cambios de verdad sustantivos en los defensores. Luego, en relación con lo que dijo Carlota, pues me parece muy esclarecedor y creo que me permite también repensar de otra manera este asunto y este malestar que hay en relación con el litigio climático como un escenario que se le llama litigio estratégico, pero que es una puesta en escena versus otro tipo de asistencias legales a comunidades que no son tan rimbombantes, pero que sí tienen unos efectos en la vida de las comunidades real, pero que entonces, claro, ¿qué abogado sale y dice, no, yo no hago litigio estratégico? O sea, pareciera que decir que yo no hago litigio estratégico pareciera algo malo, corto, insuficiente, débil y demás, cuando en realidad creo que el mundo está hecho de esos litigios muy localizados, que también son gestas en su contexto, pero que tienen unas particularidades, digamos, muy lejos de lo espectacular, ¿no? Y finalmente lo de Carla, muy interesante algo que ella dice en relación con el tema de participación, y es la rutinización de la participación en el momento posterior al cumplimiento de la sentencia, pues de nuevo ralentiza el cumplimiento de las obligaciones del Estado. Entonces estamos dando unos círculos ahí viciosos alrededor de eso. Entonces, nada, quería decir, qué pena que me demoré, pero es que todas son tan buenas que quise hacer ese comentario.
Bueno, muchas gracias por esas preguntas y por esos comentarios tan interesantes y tan útiles. Respecto a la pregunta que hizo el señor Camilo sobre la conflictividad en países insulares en el Caribe, de todos los conflictos que tenemos en América Latina y el Caribe fueron aproximadamente unos 780 casos, entonces digamos que casos específicos ahora no me acuerdo, pero sé que por ejemplo hay muchos casos en el Caribe que se relacionan con proyectos ecoturísticos y muchas de las luchas de estas poblaciones contra resorts, hoteles y proyectos ecoturísticos que tienen que ver más que todo con capital transnacional. Me acuerdo de un caso muy particular, que no sé todos los detalles, pero un caso de unos isleños en una pequeña isla en el Pacífico, que trajeron un caso de litigio climático, creo que fue en la República Checa, por la apertura de un proyecto de una eléctrica a carbón, porque pues los efectos del cambio climático están afectando muy claramente a estas poblaciones. Entonces eso también nos muestra la conexión que hay entre lo local y lo global, y cómo los impactos climáticos y bueno, los efectos del degrado ambiental tienen impactos muy concretos a nivel local, pero que también sus causas pueden ser a nivel global. Entonces, eso. También hemos visto que en la base de datos el litigio es una de las estrategias que usan los individuos o los actores para reaccionar contra el degrado ambiental, pero también hay diferentes formas de movilización. Entonces, hemos visto que también hay movilización a través de consultas populares, protestas y diferentes tipos de formas de reacción. Así que en el Caribe puede ser que en algunos años, o tal vez no hemos encontrado la información disponible online, pero puede que haya más litigio climático en los próximos años en el Caribe.
María José.
Bueno, sí, con respecto a la pregunta del compañero, siempre es negativo, detrimental, que un país latinoamericano no pertenezca o no sea parte de un convenio, porque lógicamente es un marco jurídico que no ampara internacionalmente, en este caso cuando usted mencionaba a Venezuela, y claramente es muy negativo para las personas que solamente tendrían la vía doméstica para buscar reparaciones, acción estatal, etcétera, ¿no? De hecho, de que Estados Unidos no haya suscrito la Convención Americana, sí es problemático. Por ejemplo, si vemos la cuestión del litigio que tiene que ver con temas ambientales, por ejemplo, se me viene a la mente la petición a Tabascan ante la Comisión Interamericana, por ejemplo. Era ahí esa comunidad que queda entre la frontera entre Estados Unidos y Canadá presentó una demanda en contra de, una petición, mejor dicho, ante la Comisión Interamericana en contra de Estados Unidos por todas las argumentación que tiene que ver con el cambio climático. Sin embargo, en ese tipo de petición, por ejemplo, no he tenido yo acceso al documento, o sea, a la petición sí, pero al razonamiento de la comisión no. Pero, por ejemplo, la comisión no desconoció el tema, no lo declaró inadmisible. Creo que también tiene que ver con, de nuevo, cómo desplegaron un poco estratégicamente los argumentos. Creo que, porque el litigio climático, claro, estamos hablando de una petición del 2006. Ahora hay más argumentos que puede uno, porque se han desarrollado estándares. Y eso es un poco lo que me conecta al comentario de la última compañera. De hecho, sí, o sea, si vemos el desarrollo normativo de la Corte Interamericana a nivel, desde una perspectiva local, es bastante limitado, inefectivo. Y sí, desde la perspectiva local, lamentablemente no llega el sistema, ¿no?, a las comunidades. Yo vengo de Ecuador, Sarayaku, tienen problemas. Excelente jurisprudencia, consulta previa, estándares, etcétera, pero todavía la siguen peleando desde el 2012. Entonces, pero dicho esto, y ahora sí es un poco enmarcándolo con lo que dijo Carlota en su presentación, que me gustó mucho, porque ella presentó distintos marcos conceptuales en cómo categorizar, ¿no?, los distintos actores y sus estrategias, etcétera. Yo sí creo que el sistema interamericano sí sirve pero nuevo desde el punto de vista del litigio estratégico, porque si por ejemplo lo vemos ahora con la opinión consultiva sobre emergencia climática, ¿no? Que se van a hacer las audiencias públicas ya a finales de este mes y en mayo, por ejemplo. Son 119 personas que han intervenido como amicus curiae. Entonces, yo creo que el valor del sistema interamericano definitivamente es la creación de estándares, y la creación de estándares para influir en otros sistemas jurídicos a nivel internacional. En el sentido, por ejemplo, se viene, por ejemplo, la opinión consultiva ante la Corte Internacional de Justicia. La Corte Interamericana va a desarrollar, por ejemplo, estándares. Y el sistema interamericano, si uno ve, por ejemplo, todas las participantes en esta última opinión consultiva, tienen distintos orígenes. No son todos, o sea, hay mucha, el sur, el norte, el centro, etcétera. El sistema interamericano es un sistema abierto para no solamente la gente de América Latina o de las Américas. Entonces, desde esa perspectiva, los desarrollos normativos que elabora el sistema interamericano son valiosos para influir y promover el diálogo a nivel horizontal, ¿no?
Gracias, María José. Carlota, ¿tú quieres reaccionar?
Yes, I will reply in English because I'm more fluent, but I understood the questions and the commentary. So yeah, thank you for this conversation. I think it has been really enriching to not only hear your presentations, but also your comments, and to see also the convergences in our works, the common threads. So on the commentary, indeed, the message does not want to be a stigmatizing message towards strategic litigation per se, because as it has been said by the co-panelists, strategic litigation is a very important endeavor to create legal standards that then can be used in other cases, and also can be used in grassroots-led cases, and in general, to build pressure, to shift narratives, and to have the law respected in new ways. And I think there is a very interesting example of that in a case in Brazil that involved, among others, the landless movement, which is a movement that appropriate lands in Brazil that belongs to big landowners to do agroecological settlements, and to talk about the issue of land distribution in Brazil, but also to educate about what is agroecological transition. So this is a grassroots organization, but a powerful one, that was involved in a climate case because they were going to build a thermoelectric plant in one of their territories. And the case started as a case to defend this community, to defend other indigenous communities. But then there was a collaboration between these organizations and more climate-focused organizations from Brazil. There was funding, there were documentaries about this case. And then in the end, there was also collaboration with an association of public ministers. And what they asked in the case was also to change the law to include climate change consideration in environmental impact assessment. So this is really a case where we have a combination of a grassroots organization and a specialized NGO, and also of a local struggle, and of the climate struggle, which is a national one and the global one. So these kinds of collaboration are really important. Strategic cases are really important, but what is also important is indeed the method, because I think there have been cases where it has been shown that when organizations lack to involve really affected communities, fail to hear their views, they might end up obviously accidentally also hurting these communities. So in some cases, it might be better not to start a case, or to wait for the case to be also political, in order to start it, because legal cases can be very long and they can just lose the public attention, or simply the judge maybe might not really be receptive when they don't see that there is a strong political mobilization. So I think this methodological issue is really important also for the effectiveness of all these judicializations that we are seeing, and also to take into account, as it has been said, that judicialization or legal mobilization is just one part of a larger endeavor.
Very interesting reflection. Carla, ¿estás ahí?
Sí, estoy acá.
Carla.
No, en relación a lo que preguntaba el compañero sobre nuestro nuevo presidente, solo decir que en términos concretos todavía creo que es muy reciente, acá nos parece que está hace meses por la cantidad de la avanzada que está llevando adelante, pero todavía tal vez es muy pronto para saber qué sucederá en relación al litigio ambiental en particular, pero sí se puede decir que primero nuestro Ministerio de Ambiente pasó a ser una secretaría, que se redujo ya se está queriendo reducir a la mitad el personal empleado en la autoridad de Cuenca, por ejemplo, Matanza Riachuelo, y bueno, en el Estado en general, una de sus políticas fue frenar la obra pública, que después, bueno, en los hechos no sucede tan así, pero frenar la obra pública en su conjunto, frenar la política habitacional, con lo cual estamos en una situación muy complicada. Bueno, además de una serie de políticas que favorecen en todo el país a los grandes propietarios de la tierra, que son responsables de muchos de las mayores problemáticas ambientales vinculadas con el extractivismo que tenemos en nuestro país, y bueno, el ingreso de capitales extranjeros, etcétera. Pero bueno, para hablar del litigio en particular, sí puedo decir que no por ahora, tal vez en términos de lo ambiental, pero sí que se está viendo que el Poder Judicial o algunos jueces se están interponiendo. Lo que quiero decir es que el freno hasta ahora de algunas de las medidas más relevantes que él está queriendo llevar adelante están siendo por la vía judicial, ¿no? Por la presentación de amparos, distintos pedidos para la no derogación de leyes, por ejemplo, las leyes de tierras, las leyes contra incendios, las leyes de bosques, con lo cual el Poder Judicial está, contrario a lo que venía pasando quizás, en términos de la política general argentina, está tomando un rol que puede llegar a ser, todavía no sabemos, pero de suma relevancia, me parece. Todavía no la Corte Suprema, pero sí de muchos jueces está saliendo esa iniciativa que está mostrando ser una herramienta muy relevante en este momento, también en términos de políticas laborales. Pero bueno, habrá que ver cómo se desarrolla eso. Y después simplemente tomar lo que decía la compañera del tema de la rutinización de la participación, que me parece súper interesante y relevante. Bueno, yo trabajé mucho también sobre los tiempos judiciales, ¿no? Y la relación entre los tiempos judiciales y los tiempos de los procesos ambientales, pero también de las poblaciones, ¿no? Y también del Poder Ejecutivo, y lo importante que es considerar eso a la hora de ver si estos procesos terminan garantizando o no los derechos, ¿no? O vulnerándolos en alguna medida aún más, o generando nuevas vulneraciones. Y este tema de la rutinización, ¿no? De que ahora quizás, no sé, las mesas de trabajo que se supone tienen que llevar adelante el Poder Ejecutivo o el Poder Judicial terminan siendo algo que con lo que ellos tienen que cumplir, ¿no? Ante la Corte o ante los juzgados, más que espacios efectivos de participación. Y que incluso nuevos conflictos que han surgido en la cuenca, que no estaban en los planes de saneamiento originales, no se incorporan a ese plan, que también tiene que ver un poco con el hecho de que esté como encorsetado en este mega litigio, ¿no? El tema de la judicialización un poco trae eso en este caso también. Pero bueno, y solo para cerrar, que también sí se ve la gran diferencia entre los barrios que están afectados por la causa, que la diferencia central tiene que ver con los grados de organización previos o que a lo largo de estos años se han desarrollado en estas poblaciones. Son las que motorizan después efectivamente, al menos en este litigio, ¿no? Más que y los abogados de la defensa, de la procuración, pero son esas acciones las que motorizan la implementación de las políticas y de la ejecución de la sentencia más que otra cosa, digamos. Bueno, eso. Muchas gracias.
Gracias a ti, Carla, y gracias a todas y a Daniel por un panel súper interesante. Entonces, vamos a hacer una breve pausa. Vamos a tener dos sesiones paralelas, como lo ven aquí en el chat. Pero tenemos. Vamos a hacer una breve pausa de 10-15 minutos y nos desplazamos a los salones y a los enlaces que tienen aquí en el chat. So for those who want to connect to the next parallel sessions, the links are provided here in the chat, and we'll start in about 10 to 15 minutes.
Hi, Jerome, can you hear me?
Hey, yes, I can hear you.
Okay, thanks.
You see me?
We can start now.
Vale.
Thanks.
Thank you. Okay, so we can start. Welcome to this panel about international environmental law and regimes. So we'll have 4 participants today. We'll have our first participant from the Raoul Wallenberg Institute of Human Rights and Humanitarian Law in Sweden, Neshan Gunasekera. And then our second presenter will be João Teixeira de Freitas, who's a PhD candidate at the ERC Curia Veritas project at the Brussels School of Governance. I didn't present myself. I also work at the Brussels School of Governance, and I joined the same project, the ERC Curia Veritas project, as an associate researcher a few weeks ago. So João will be our second presenter. Then we'll have Joanna Cornelius of the Faculty of Law of Lund University in Sweden. And our last participant will be Sana Akhtar of the Law Department of Kennett College for Women in Pakistan. I'm trying to see how much time we have. We'll start with the presentations. And then we'll see how much time we have left for the questions. But so I'll ask the presenters to not to take too much time, because, well, actually there's a lunch for on-site participants in Bogota. But I guess, like, if we have more questions online, we can keep answering questions afterwards. But so yeah, try to stick to a presentation of maybe 15 minutes or something. So without further ado, regarding questions, you can ask them in the chat, or you can also raise your hand via Zoom, and so we'll take your questions later, but after the presentations. So without further ado, we'll start with the first presenter, Neshan. The floor is yours.
Pleasure. Thank you, Jerome. Just to check the audio, you can hear me?
Yep.
Perfect. Great pleasure to connect with everybody and on this esteemed panel. Thank you to also Dr. Claudia Ituarte Lima, who is the lead on environmental thematic group here at the Raoul Wallenberg Institute, where I'm connecting from. So good evening, and good morning, good afternoon for all those people connecting. I think we are meeting at challenging times. I think we've heard this from over and over, where it's where the nexus between armed conflict and climate has brought us to the precipice of doom and gloom. But I hope not to dwell too much onto the doom and gloom part, but speak a little bit about the inspirational movement that is going on across the world, and in specifically to the international level, where a group of concerned global citizens have moved the International Tribunal of the Law of the Sea for an advisory opinion on climate change. Simultaneously, in another part of the world, a group of young people in a classroom has moved the world to bring the issue of climate change to the highest United Nations judicial organ, the International Court of Justice, recognizing that there is a number of cases, I think over 2,000 cases going on on climate change and environment at the local, national, regional level, including the Inter-American Court of Human Rights. And next Tuesday here in Europe, in the European Court of Human Rights, we are anticipating 3 important decisions on the 9th of April. My topic is protect our seas, protect our climate. Could the Tribunal of the Law of the Sea and the International Court of Justice correct our path? Law of the Sea, both technically and physically, covers almost 71% of the planet, because the seas cover 71% of the planet. And International Court of Justice then goes on to the rest of the planet. So I think that is the first aspect of the inspiration that these 2 cases provide given that these two cases will build on the developments and the other courts and tribunals, but will also work vice versa. And not to really focus during my presentation on so much the nitty-gritties of the questions and preempt what the decision of the Tribunal of the Law C, which we are hoping is going to be released in the next 2 to 3 months, or the International Court of Justice, which is first even to begin the oral hearings, which may be early next year. But to start talking about some of the processes that sit alongside the litigation process as we transform international environmental law into what I would call it ecological law and processes, because I think that's the opportunity that arises at the moment. And if the moment is really captured, I think it would lead to strengthening what I called the principle of intergenerational equity, because we see a pattern on intergenerational partnerships, whether it's be young people or old people here in Europe or in Latin America, that is pushing the member states to take action on the climate issue. So how do we see international evolution? So I'll take the phases as the first processes leading to litigation before it goes an ICJ. Then the processes whilst these cases are being heard by these tribunals, the Tribunal of the Sea in Hamburg, and ICJ at The Hague. And finally, what happens after an advisory opinion is given from these tribunals? What are the processes that happen? So let's take a Tribunal of the Law of the Sea, which had a bit of a head start from the ICJ going into the oral hearing last September in Hamburg. Very interesting group of people calling themselves the Commission of Small Island States and International Law, which was registered as an organization in the UN in the UN Secretariat only in February 2022. And in the latter part of 2022, the same group of lawyers, diplomats, and states pushes the Tribunal of the Law of the Sea for a very unique advisory opinion on climate change, which is a first time use of that advisory opinion of the Tribunal of the Law of the Sea. So I wanted to kind of dwell a little bit on this. How could a new organization such as COSIS move this issue at such a pivotal moment in history? I think this also goes to look at how the Tribunal of the Law of the Sea was constituted. Almost 50 years after the International Court of Justice. Now, the International Court of Justice was established in 1946, and the first cases before the Tribunal of the Law of the Sea didn't start till October 1996. And another important point here too is recognize that ITLOS has almost 172 UN member states accepting its jurisdiction, whereas the International Court of Justice has only 74 accepting its compulsory jurisdiction, although with almost 21 contentious and advisory opinion cases before the ICJ at the moment, over 140 cases are either intervening or before the International Court of Justice at this junction. Why am I highlighting this? Each one is a story that inspires a wider discourse. Now, stepping back from the usual litigation process, there was a scourge of social media conversation at the beginning of the year, especially when the genocide cases were taken up at The Hague. Plethora of legal opinion by lawyers, by former judges, but also young people who had very little idea of what was international law, but really taking an interest in this process, of which was happening somewhere far, far away from their village or communities, but knowing that this decision has an impact. I think that's a wonderful aspect of the processes of litigation that we sometimes do not really take cognizance of. And then the second phase, in the interest of time, Jerome, the second phase is what actually goes in-house. What happens in the tribunals? What are the type of judges who hear these cases? What is their background? What is their family background? Where do they come from? Because the time they step onto International Tribunal of the Law of the Sea or onto the bench at the International Court of Justice, they leave their national jurisdictions behind. At least on paper, this is as a requirement, because both the ITLOS Convention of the Law of the Sea and the statute of the International Court of Justice specifically mentions that they become part of a global institution, brings international environmental law, brings international law principles, and they're supposed to, in the terms of the statute of the International Court of Justice, represent legal systems of all civilizations. Now, I would hold this thought for a moment because although it says legal systems of all civilizations, there are restrictions as both these tribunals are still predominantly member states-driven processes. And even today, indigenous peoples have had very little opportunity or no opportunity to be directly represented in these institutions, although there has been somewhat of innovations built in over the last few years, including allowing international organizations such as IUCN to come on board. Now, with regard to judges, I want to mention here a privileged period of my professional life at very early stage that I got to work with late Judge Christopher Veeramantri, the former vice president of the International Court of Justice, who was considered as a pioneer and a father of international environmental law. Over a quarter of a century ago, he was a vice president of the ICJ, and he gave a separate opinion in the Gabčíkovo-Nagymoros case, which was a contentious case between Hungary and Slovakia, which brought the concept of sustainable development and made it to principles of international environmental law. And in his separate opinion, he articulated what is principles of trusteeship, building in wisdom from customary and indigenous systems, as well as religious systems and philosophies, really broad basing the jurisprudence of the International Court of Justice from a very much a Eurocentric monocultural system or body of law to a global jurisprudential body of law. And I think that is an important aspect of evolution. And here we are a quarter of a century later looking at possibly the next phase of moving international environmental law to bring the earth systems aspects into it. So the role of judges are absolutely important. Now let's look at the fantastic young people from the Pacific Island states. At the height of the pandemic, they were trying to go online to join classes. And these are, mind you, not law students alone. These were, in fact, art students and political science students. What happened? They had a mock trial on possibilities of taking this question to the International Court of Justice. Fast forward that to March 29th, 2023, exactly a year ago, where they moved the whole UN General Assembly for a very unique consensus resolution on taking the climate issue to the highest court in the UN. And this, I think, is a fantastic example of moving the litigation process in an interdisciplinary way where young people inspires a global movement. And now today, World Youth for Climate Justice has taken up this initiative, drafted their own respective advice for policymakers, draft submissions to the International Court of Justice, and reliving the stories, such as those who represented future generations in indigenous systems at The Hague. The final phase is what happens after the opinions is given. Now, the opinions, as we know, is communicated to the respective assemblies for its implementation. And then it's applicable to all member states of the United Nations and those who have signed on to the Convention on the Law of the Sea. And that's a unique opportunity to see how implementation goes beyond just the member states, but the respective policymakers, the parliaments, the civil society, who's actually be taking the leadership to tell and relive the stories. And the final point, Jerome, I wanted to kind of leave with, and then obviously possibly come back, is the good sciences, as it is called, whether it's the IPCC or the developments that are going on with Club of Rome report on Earth for All, allows a question of right to science and the good sciences to be combined with the principles of international environmental law and its evolution. And that's a unique stage at which we are looking at environmental and climate litigation. And that's a very key point that I think if you're looking at whether these tribunals can put us in the correct path of achieving the challenges of climate change, it is groups coming together, reliving these stories and understanding that the science law overpass is one of the key ways to build up a socio-political and socio-environmental movement across generations. I will leave my thoughts at that and then come back to the questions later on. Thank you, Jerome.
Thank you very much for this very interesting contribution. So again, I remind everyone listening that if you have any questions, you can ask them in the chat or raise your hand for later. We'll come back to you. So now we'll move on with our second presentation of the day. By João Teixeira de Freitas, a presentation titled Environment Value Change Due Diligence and Stakeholder Engagement, an explanatory study on value change due diligence requirements. João, are you ready?
Yes, I am. I believe you can see my presentation already.
Yes.
Okay,
yes.
Perfect.
Yes, we can see it.
So thank you very much. I will try to keep it to 15 minutes starting now then. So my name is João Teixeira de Freitas. I'm a PhD researcher at the ERC Curia Virides project. And within it, my PhD project is focused on studying value chain due diligence obligations and how they are interpreted and applied by different dispute resolution mechanisms in concrete environmental conflicts. So today, I prepared to you a small presentation that is a fruit of my research on this topic. So as a form of introduction, I believe most of the participants would know this, but the origin of value chain due diligence started, by being human rights value chain due diligence with the UN guiding principles that were endorsed in 2011. But shortly after, the OECD guidelines for multinational enterprises were also adapted to align themselves with the UN guiding principles, and thus took in this concept of corporate risk-based due diligence into their own soft law framework. And nowadays, around the world, we are seeing few countries which are already starting legislative initiatives, which are hard law on this subject, and enacting value chain due diligence laws. We have the French law on droit de vigilance, which is already in vigence since 2017. We have recently a new law that has been approved and that is now applied in Germany, the Supply Chain Act. And obviously, we also have the recently approved directive on corporate sustainability due diligence that has been approved by the EU member states, which means that soon enough, all countries around Europe will have their own legislations on value chain due diligence. What I'm bringing you today is basically a study about decisions of national contact points. So the network of national contact points is established by the OECD, and basically these are national non-judicial mechanisms that are established in OECD member countries and in other countries who also adhere to this system. And they basically are alternative means of dispute resolution. So the type of decisions that comes out of these dispute resolution bodies is not so much similar to the ones that we would see in courts, but still, I would argue that what they are doing in most of the cases is taking a normative text, which is the one contained in the guidelines for multinational enterprises, and interpreting it and applying it to concrete contexts, many times involving environmental conflicts. So while the decisions that we have under the French law and the German law are already being litigated, they are still mostly not finished yet. So it's good to depart already from this point, because these organs have already indeed been applying these norms on due diligence for quite a while. So this is what I'm bringing you today. It's an analysis of how I like to call it their soft case law on this issue. I'm not going to cover all aspects of due diligence. So just on the first slide here, you have a summary on the left side that basically tells you what are the main steps of due diligence. I'm not going to go very much into this part, because today what we are going to focus on is, in fact, stakeholder engagement. These are just some texts from the guidelines, basically containing the obligations or the recommendations that corporations should conduct risk-based due diligence, not only to avoid causing or contributing to adverse impacts through their own activities, but also seeking to prevent or mitigate adverse impacts that they may be linked to through their operations, products, or services by a business relationship. And focusing now on the subject of stakeholder engagement, this is basically what the guidelines say to us. Under the chapter of the general policies, they say to us that corporations should engage with relevant stakeholders in order to provide meaningful opportunities for their views to be taken into account in relation to the planning and decision-making for projects or other activities that may significantly impact local communities. And then again, on the environmental chapter, we have also a recommendation that they should engage in adequate and timely communication and consultation with communities directly affected by the environmental, health, and safety policies of the enterprise and by their implementation. So basically, in this study, what I'm looking at is how these national contact points have interpreted these dispositions contained in the guidelines in concrete environmental disputes. Just to give you a little bit of insight onto the methodology that I adopted for this study. So basically, as you may know, the OECD keeps a database where all the cases that went through national contact points globally are basically compiled. I went through this database. I made an initial selection of all the cases that were presented. But in fact, the ones that interest us are the ones that come after 2011, which is when the guidelines were adapted then to include this standard on risk-based due diligence, basically. So after 2011 and until the 8th of February of 2024, this year, we had a total of 423 cases that had been lodged on this database. But out of those, not are interesting for my research purposes. So then I went to read all the summaries of the cases, as you can see here in the slide, to try to understand which ones really are dealing with environmental problems and which ones are dealing with problems of other natures, to try to flesh out only the environmental cases. So after fleshing out the environmental cases, I came up to the conclusion that after 2011, we have 147 cases in the national contact points that dealt with conflicts that also raised environmental protection concerns. But also not all of them are important to this study because not all of them relate to the recommendations of stakeholder engagement contained in the guidelines. So then there's a further need of fleshing out which ones really contribute materially to the development and interpretation of the stakeholder engagement standard that is contained in this due diligence obligation. So right now, at this point in my research, I can say that there are about 15 or 20 cases that materially have contributed in some way to develop the interpretation of this concept of stakeholder engagement. Due to time constraints, I'm not going to cover all of these cases. I'm just going to bring you 4 examples so you can grasp a bit what I'm talking about. So this was just an Excel table of how things looked on my side for a while. And now let's then move to the second part of this presentation, which is the case law analysis or soft case law analysis. Here, I'm going to bring to you 4 different cases from 4 different NCPs, which had different outcomes. So there is one case that I'm going to show you that was actually rejected. There is another case where the national contact points limited himself to issuing recommendations for the enterprises. But there are also other cases where non-compliance with due diligence duties is clearly affirmed by the national contact points. Nonetheless, with all these possible outcomes, they still manage somehow to interpret this concept of stakeholder engagement and what it can mean in practice for corporations that are bound by value chain due diligence obligations. So the first case I'm going to bring to you is a case that was addressed by the Canadian National Contact Point between 2016 and 2020. So this is date of the complaint and date of the final statement issued by the National Contact Point. This case is called Southeast Alaska Conservation Council versus Imperial Metals Corporation. I will bring a little map just to situate you a bit on where these things are happening. So this is the northwestern coast of Canada and the US, near the Canada-US border. So we have basically a part of Alaska and a part of British Columbia here that have a frontier. And what was happening here was that the complainants, Southeast Alaskan Conservation Council, were complaining about the impacts of the Red Chris mine operation. This is a mine that was developed by Imperial Metals Corporation that was owned by this enterprise, which is a Canadian enterprise. And the mine is basically placed here. And the orange line is basically a river, which is called the Stikine River. And the main problem in this case was that Alaskan communities that were living in downstream from the river were complaining about the downstream effects on the Alaskan ecosystem and the fisheries that the impacts of this mine could have for their livelihoods. And so what did they complained also obviously that they were not consulted and that they were not engaged with during the process of approvals and constructions and initial operations of this mine. And what did the national contact point in the end assessed? Actually, the national contact point said that in this case, the corporation indeed did violate the recommendations on due diligence in the matter, because the national contact point did not receive any information to indicate that the company consulted or communicated with Alaskan communities located in the Stikine River watershed, or disclosed information to them, or that this is ongoing. So despite the fact that the company had already consulted, in fact, with US authorities and with the Tahltan Nation, which is an indigenous community of Alaska, there were apparently some other communities that were not consulted by this enterprise. And because of this factor, the national contact point came to interpret this as a violation of the guidelines in question. And it also said that basically this Imperial Metals Corporation should not limit the identification of affected stakeholders to what is required legislatively, in this case by Canada, because the mine operations were basically located in Canada, and thus the law of Canada naturally applied as the host country where the activities are taking place. The second case I bring to you is a case that was addressed by the Denmark National Contact Point between 2017 and 2018. And this case did not end up well for the claimant because it was rejected by the National Contact Point. But what happened in this case was that there was a mine in Armenia, and EKF, which is the Danish Export Credit Agency of Denmark, basically had backed a loan that was made through a Russian bank to this mine, in the condition that this mine would buy some excavation material from a Danish company. But what's interesting in this case is so in this case, the National Contact Point actually determined that there was no violation of the guidelines. But what's interesting to note is, why did it say there was no violation of the guidelines? Basically, the Danish credit agency had directly made a contract with the corporation that was developing the mine in Armenia. And in this contract, it had included clauses concerning stakeholder engagement. And not only this, but the National Contact Point considered that it also did monitor the client during the investment, but, and importantly, it also met directly. So the Danish Export Credit Agency met directly with local stakeholders and local communities. And this was crucial to consider. All these factors were crucial to consider that, in fact, this corporation was in compliance with its obligations on value chain due diligence. In case 3, we have a case that takes place in Tunisia, basically, and this case involves a multinational company involved in oil extraction. This is the Perenco Group, and the claims on this case were related to the use of hydraulic fracturing in 2 concessions that the Perenco Group operates in the Kebeli Governorate in Tunisia, the Bag el Tarfa and the El Franig concessions. So in this case, the communities that live in this region complained likewise that the corporation had not engaged with them, and the national contact point agreed with them that indeed there were violations by the Perenco Group in the manner that it managed stakeholder engagement in this case. And it finally recommended that Perenco Group needs to establish a group policy on facilitating engagement with local stakeholders, and that this policy should be endorsed by the group's executive management. So these are all recommendations that basically reveal us a bit mostly the procedural ways in which stakeholder engagement can be achieved. Then finally, and to finish, we have a final case, this time in South America, that was handled by the Chilean National Contact Points, which is the group of neighbors of Villa Estadio against Lundig Mining and Sumitomo. This case is again about a mine. It's called Minera Candelarias operations, and it's near the town of Tierra Amarilla in Chile. And what happened in this case was that the National Contact Point issued recommendations to the enterprise that imply with enough certainty that its conduct was not perfectly aligned with its obligations of due diligence. With regards to stakeholder engagement, it noted, for example, that the enterprise needed to draw up minutes of meetings and agreements between the enterprise and the local community. And it noted also that engagement should be ongoing, should be a two-way process conducted in good faith, and that should be responsive. More than that, it further noticed that it does not entail a stakeholder's influence in business management, but only that the view of those who might be affected by enterprise operations is taken into consideration. It referred also, importantly, that because this company was owned by Canadian and Japanese capital, it was expected that this company also applies higher standards on stakeholder engagement, which are similar to those that are expected in their home countries, provided that they are compatible with Chilean national laws and regulations, in order to also further its positive contribution to the progress in the host country. So I only have just one final slide, basically to conclude with a summary of the conclusions that we can have from these 4 decisions. The first one is that companies bound by value chain due diligence obligations need to document stakeholder engagement activities performed in order to comply with legal norms, or otherwise it will be very difficult for them to prove that they have conducted this stakeholder engagement. Further than that, stakeholder engagement standards may be higher than those set by the national laws of the countries that are hosting the economic activities in question. This was seen, for example, in the case of against Lundig Mining. And then policies of stakeholder engagement should be established at enterprise group level and be endorsed by the executive management of the corporation. These could be also all nice conclusions, but there are some problems. I can take more questions on this later because I'm already a bit over time. But basically, there are some problems with interactions between jurisdictions. For example, when certain jurisdictions legislate in a way that allows certain types of economic activities to take place, for example, fracking, activities that are arguably understood as having major environmental impacts. but also this question between how should the process of stakeholder engagement be interpreted, more on the material side or on the procedural side. So obviously the company can document all these processes, but then what actually matters is if anything was achieved during these stakeholder consultations, if any agreements with the communities was made, and perhaps not all national contact points are making this further assessment of checking the quality of the stakeholder engagement that was done by the enterprises. Thank you very much, and I'm happy to accept more questions at the end and to continue the debates.
Thank you very much indeed, Joao, for this presentation about due diligence and stakeholder engagement. So now we'll hear Joanna Cornelius from the Faculty of Law of Lund University in Sweden, and she'll tell us all about the concept of public participation in international environmental law and negotiations, from the Aarhus Convention to the Escazú agreements, and beyond. And so, Joanna, if you're ready, the floor is yours. I'm not sure if, so you're sharing your screen, right? Joanna?
I think she's having internet problem.
Oh, okay. So maybe we'll see if she pops back up in the next 10 seconds. Otherwise, Sana, if you're ready, maybe we can start with your presentation and then we'll listen to Joanna later. Is that fine with you?
Okay, Joanna is connected.
Yeah, so if you can unmute yourself, or how does this work?
And you can
Oh,
presentation.
I think that Joanna is back.
Yes.
Hey, Joanna, can you hear us?
Sorry for that. Just as I was sharing my screen, this happened. So I will try again and hope
To share your
it
screen,
will
okay.
be easier this time.
Oh, there we go.
Is it working?
Yes, you can just go to full screen mode. That's fine. And yeah.
Thank you
Thank you.
so much. Can you hear me well?
Yes, we can hear you well.
Thank you. I'm very pleased to be invited to this workshop, and I have appreciated to listen to these previous presentations. I think we would have a lot to talk about. I'm unfortunately in Stockholm right now, and I understood maybe you also are in other countries. I will today share some reflection on my PhD project, which is the concept of public participation in international environmental law and negotiations, which take us from the Aarhus Convention to the Escazú Agreement. And a while into my doctoral work, I understood that this will be much a story at the intersection of human rights and the environment. First, I would like to give you some brief conceptual background to the involvement of the concept of public participation in environmental matters. While aspects of public participation long have been present in national context as well as in international negotiations, is with this Principle 10 of the Rio Declaration that it gained global recognition. And since 1992 and the Rio Declaration, the importance of public participation in relation to sustainable development has been phrased in numerous policy documents. The Principle 10 of the Rio Declaration, you may be aware of. And I also wanted to add one of these affirmations that can be found in goal 16 of the 2030 Agenda for Sustainable Development, which sets up the target to ensure responsive, inclusive, participatory, and representative decision-making at all levels. And by bringing this up, I would like to stress this strengthened focus on all levels of public participation, not only the national or local, but also the international. And although sustainable development processes has been very driven and had a great impact on the interpretation of public participation in environmental matters, it is not its only source. Public participation also has this intimate relationship with human rights, such as the freedom of association, right to consultation of indigenous peoples, the right to participate in public affairs. And this relationship has accentuated through the General Assembly resolution on the right to a healthy, clean, healthy, and sustainable environment, which, amongst others, also set focus on different sectors of the population and that are in vulnerable situations, and the need to implement multilateral environmental agreements. And to view this concept's evolution, we can use a normative lens to consider how the reasoning behind this concept, in other words, rationales or purposes for public participation in international environmental law and negotiations, has been expressed in policies, multilateral agreements by academia and other experts. And this wide reasoning that is underpinning public participation includes its relevance for sustainable development, but also the legitimacy of decision-making, the environmental democracy, the effectiveness of environmental law, and to ensure human rights. And from this involvement of the concept and this wide reasoning, we can also draw some ideals of public participation. We can crystallize that from this reasoning that relates to the quality of public participation. And one of these notions are the ideals of inclusive and meaningful public participations. And these ideals can be applied to consider how public participation has been realized and has been expressed in international environmental law. So that's a short recollection of the roots of the concept of public participation. And there are different, let's see, I don't see the, sorry. Yes, and there are different spheres of public participation or levels where public participation come. Let's see. Comes into action. Sorry, I got a step further. And today I will focus on the international environmental sphere and also look into some of the provisions that these multilateral agreements provide for public participation. And to look at the international level as well as the national level makes it also possible to see the interrelationship in between participation in these two levels. And the Convention on Access to Information, Public Participation in Decision-Making and Access to Justice and Environmental Matters, the Aarhus Convention, and the Regional Agreement on Access to Information, Public Participation and Justice in Environmental Matters in Latin America and the Caribbean, the Escazú Agreement, are valuable examples for how public participation has been expressed in legal detail in relation to both the international and national level participation. And if you look at public participation at international level, there are several factors that are relevant, including the formulation of rules and procedures through the various phases of the crafting and creating an agreement to the work under the agreement. But also important are the different institutional structures that are built under these agreements, such as which bodies are created and how they're offering capacity building and support for the public in these processes. So if we take a quick look at the Aarhus Convention, in the negotiations of Aarhus, there was an early engagement of NGOs already in the small groups that were called Friends of the Secretariat that kind of started to elaborate and formulated the draft elements for the convention. The NGOs were invited. And the declaration that sparked the development of the Aarhus Convention uttered that it should be considered with the appropriate involvement of NGOs. And this was further developed through the mandate for the negotiations. And the NGOs in this process were involved in both the working group meetings of the parties and in the smaller groups that draft the different elements of this convention. And they also had what is called a seat at the table, where they could express their opinions and also make comment on different proposals. And if you turn to the Escazú Agreement and the negotiations, this was signified from the beginning of a clear vision of the meaningful participation of all concerned citizens and with a significant participation by the public. And this was later through modalities for public participation in the negotiations. And if you look at some of the nuances between these negotiations, Aarhus, you can see, had a lot of focus on NGOs, where the Escazú Agreement viewed more the public in a bit broader sense, phrased it in a broader sense. Then what is valuable also in the Escazú process is that it was recent, both participation at the international level and for the national level were characterized by a reasoning, and also this quite detailed documents on participation by the public. And both Aarhus and Escazú provide detailed provisions on participation at its meeting. Although you can see that Escazú is a bit more detailed, and also have developed an election process for the representatives of the public in the meetings. And there are also these bodies built under both agreements that are vital because they put focus on to raise these different voices of different actors, and also offers room for discussions. And while there's a lot of discussions on national public participation, there are very rich legal detailed rules and provisions on public participation also at this international level. And all through these different phases, the definition of public and the function of various actors in the process have deciding effects on how the public participation plays out in practice. The provisions for public participation for the domestic context show some similarities, but also differences in between the agreements. Both express weaker rights in relation to decision-making processes other than activities and projects, such as planning, policies, programs, and regulations. And they also include adjustment provision, which is vital for this enabling environment for the public, and also add protection measures, and most notable is the Escazú provision on human rights defenders in environmental matters. And there are some nuances. Escazú, for example, in its provision on public participation, include a quite detailed focus on supports to groups in vulnerable situations, and also provide some attention to language barriers. This was brought up also in the Aarhus negotiation process, but it never came into the convention itself. So there you see a step taken in this inclusive view on public participation. And if you look a bit at the wider picture and see public participation through the eyes and progress through the Aarhus and Escazú, you can see the ideals for public participation in that regard. The Escazú negotiation process are an excellent view for how public participation are promoted through expressively in decisions, which provide reasoning and put forward the importance and benefits of access rights. And there is also a practice within these meetings to declare and express the reasons for public participation. The agreements also in varied ways strengthens the focus on a wider enabling environment, which is critical for public participation. And if you look at reciprocity of public participation in between the national and international level, these are just a few examples. The crafting of an agreement makes it possible to bring national experiences into the international process and build capacity amongst the public. It's also a way of information sharing to spread information on the process and the rights to a wider public. And cooperation, you can see that it's fosters some kind of cooperation, these meetings in between states and the public. It provides a room where you can meet and talk, and which also from participant has been proved to also strengthen the role at a national level. And if we see that this evolvement, it's not linear. We see this cross-pollination in between the agreements, for example, parallel with the Escazú Agreement's provision on environmental defenders. Escazú discussed and took decision on these rapid response mechanisms for environmental defenders on the international level. And this evolution is also situated in the wider sphere of international policy and law. This can be seen in relation to the right to a clean and healthy environment, which has supported the Escazú Agreement's formulation of its provisions. And it's also inspiration for other international processes to develop frameworks on environmental rights.
Joanna, I don't know if you're getting to your conclusions soon.
Yes, this is the last. I will
Great.
wrap up.
That's
So
great. Take your time.
just a short looking ahead. The strength and focus on public participation in relation to groups in vulnerable situations, the environmental defender, and other experience gained through the Aarhus Convention and the Aarhus Convention and the Escazú Agreements process may bring the experience also to other regions, which has possibilities for also starting similar processes. And I will only mention shortly ASEAN, because there has been a process for an environmental rights framework for the ASEAN regions, which now ended up in the form of a declaration, which, although not binding, this declaration brings up some important aspects that could add to the sphere of public participation. It also discusses the enabling environment, but it also put in focus on environmental impact assessment and the development of legislation to prevent strategic litigation against public participation, SLAP procedures, and also refers to free, prior, and informed consent, which, even if Escazú refers to the right of indigenous people, free, informed, and prior consent was not included in the convention. And just this morning at 5 a.m., I joined the meeting of this consultation of the ASEAN on this declaration, and they're right now taking comments on this declaration. Yes, I will stop there because I will not take too much time. Thank you very much.
Thank you very much, Joanna, for this presentation. So again, if you have any questions regarding Joanna's presentation or anything you'd like to ask to our participants today, feel free to drop your questions in the chat. So we've heard about sea protection, we've heard about due diligence and stakeholder engagement, and we just heard about public participation in international environmental law. And now we will explore the intersection of climate change and human rights with Sana Akhtar of the Law Department of Kennett College for Women in Pakistan. Sana, can you hear me well?
Yes, I can hear you. Am I audible?
Thank you. Yes, we can hear you. Do we see your presentation yet? So I send it to the CIDER team. Yeah, right.
Yes, yes. Thank you very much.
Well, thank you very much. So whenever you're ready, Sana.
Okay. First of all, thank you very much for this opportunity that I'm presenting my research on the topic of exploring the intersection of climate change and human rights law towards a right-based approach and holistic approach to climate action. Basically, I've divided this research in three objectives, and every objective has its under meaning to mitigate the effects of the climate change. Please move the slides. Thank you. The key objects, there are basically three main objects of this research. The first object is very important, that is to intersection of the climate change and the human rights law. What is the connection between them, and also look deeper into the existing legal framework. Although we have a legal framework all over the world, whether in national laws or in international laws, but still the challenges which are associated with the climate change and human rights, they are the same. And secondly, the study aims to objectively explore the latent problems in the climate action mechanism by highlighting and analyzing the roles of international human rights law in addressing climate-related human rights violations and promoting climate justice, because it's very badly affecting the human rights, like right to life, or right to food, safety, home, all that. And lastly, this research intends to contextualize and underline the existing practices to strengthen the human rights principle, to enhance climate change mitigation and adaptation strategies for the development of just and sustainable response to climate crisis. And this research basically will help to build social-legal scholarship by analyzing and juxtaposition the critical role of the components that are involved in regulatory mechanism of the climate action, because we have the mechanism, we have the policies, we have the laws, but the problem is that the major contributors to the climate change, they are not following those mechanisms, although they are ratified those conventions of the legal framework, but they are not truly apply or implement those laws or framework. Please, next slide. There is a relationship between the climate change and the human rights. Given the actual and potential human cost of climate change, including the UN estimation that nearly 50 million more people will be at risk of being hungry, and the threat posed by the rising sea levels to numerous islands and coastal communities, the human rights-based approach to combating is not surprising. Let me give you the example. And recently in my country, Pakistan, the people are facing the flood, and millions of people are migrated from that particular area because of the effects. All the Pakistan is not contributing too much to the greenhouse gas emission, but it is badly affected due to the climate change. And according to OHCR, it is evident that the anticipated climate change related effects pose a threat to the effective exercise of a number of human rights, including the right to access to safe and sufficient food, which is very important, which is the basic human rights, and also that is enumerated or incorporated in the UDHR or the fundamental instruments which are relating to the human rights, and also the water, as well as the right to good health and adequate housing, because it's very important for living as a human being. Please, next slide. Please, next.
It's a little bit.
Please, next, please.
I already passed the next slide.
Yes.
Can you see it?
Yes.
Okay.
Okay. This is basically showing the importance and showing the importance or the interest of the Human Rights Council regarding the basic right of the human, that is the right to life, which is very important and which is badly affected by the climate change, not in the developing countries, also in the developed countries, and most effectively the countries which are affected by the adverse effect of the climate change are the developing countries. Please move the next slide. As the slides show that how climate change affects the human rights, the very important is the right to life, which is badly affected, and the right to food. More interestingly, I want to share that many countries, not only the developing countries, but also the developed countries, they do not have the express provision regarding the environment. Even though in Pakistani constitution, we have the law of the land, but there is no express provision regarding the environment and the role of the judiciary. That is very important, and they develop this concept through their jurisprudence by providing that for a sustainable development, to provide the access of all living things, the basic thing, that is the right to life, that must be protected, and also the right to food, right to adequate housing, and right to water, which is very important human right, and that must be protected. Please, next slide. OHCR in 2009, its report that basically draw the relationship or intrinsic link between the climate change and the human rights, that conclude that irrespective of whether or not climate change effects can be construed as human rights violation, human rights obligation provide important protection to the individuals who are affected by the climate change or by measures taken to respond to the climate change. This basically shows that this has a very close nexus between them. When there is any thing that appear that change the climate of a certain area or a certain region, it basically affect the human rights. Please, next slide. And there are human rights law that basically play a very important role in the promotions of international and national policies that making the area of climate change more important, and it also provides remedies to the individual if their rights are effective due to the climate change. Specifically, there are some communities which are adversely affected from the effects of the climate change. They are the indigenous communities, and IHRL provide an avenue to individuals and the community to seek redress for harms caused by global climate change, and certain rights which are relating to the life, health, food, shelter, and water, they are plainly affected by the climate changes. And these are regions, specifically the South Asian regions, they are badly affected from the adverse effect of the climate, and numerous human rights are impacted by the climate change. And the first and the foremost right, that is the right to life, that is recognized in 1976 in International Covenant on Civil and Political Rights. And it also paved the first step towards the importance of this right, because it is very important if a person wants to live. So this his or her basic right is that he must have a good environment to live in without any adverse effect. Please, next slide. There are certain numerous events which also affect the human life, like the hurricanes, severe weather conditions which currently the world is facing. And there are certain many international conferences or the international organization, they are conducting the seminars to give the awareness to the peoples, because these are things are very important, and to give the awareness to the people regarding what the adverse effect the countries, the states are facing due to this climate change, due to the severe weather events, the climate shift. The weather shifts are changing, and hurricane, typhoons, and the heat waves and the flash floods, they are causing massive loss of life. And we have seen this example recently in 2023 and 2022. And if I talk about the region, South Asian region, specifically the Pakistan, the UN General Secretary called the region of South Asian as the climate hotspot. Please, next slide. There is a framework on the climate change, and there are basically deals with these things to mitigate the effects of the climate change. Particularly, some treaties like United Nations Framework Convention on Climate Change, and the implementation mechanism, which is very important. And the second one is the Kyoto Protocol, that is also playing a very important role, but its implementation on the developed states also. But there is another agreement which is very important, that is Paris Agreement, and this is more important because it's bind the states to give the report after 5 years regarding the prevention, regarding the strategies, what they have done to reduce the greenhouse gas emissions. So this framework is very important, but somehow there are certain things in this legal framework that on some points these laws are silent, they are not proper giving the implementation mechanism. That's the reason that the developed states are taking the advantage of that, and they develop or establish their companies, or the factory there are producing more greenhouse gas emission in the developing states, because in developing states the legislation on this matter is not as much to the mark that it should be. And UNFCCC, the main international treaty governing the human response to climate change, call for the stabilization of the greenhouse gas concentration in the atmosphere at a specific level that would prevent dangerous anthropogenic interference with the climate system, because mostly the business human activities, they are playing their more important role regarding the adverse effects of the climate change. Please, next slide. There is also some treaties that set binding obligation on most developed countries to reduce greenhouse gases, and they also bind them to provide assistance or to provide the technology to the developing states regarding the reduction of the greenhouse gases. And for that matter, many conference of parties held in different eras. For instance, COP27 held in 2022 in Egypt, and during this COP2017 there was an agreement between the states that they should establish a mutual fund to assist the states that are badly affected by the climate and where the humans are suffering. And more recently, COP28 that was held in Dubai, and the purpose of that COP28, the outcome of that COP28 was to properly utilize that the fund system that they have developed in COP27, and to provide the assistance to the developing states to get rid from the adverse effect of climate change. Please, next slide. Basically, there are some barriers to address climate change may affect the enjoyment of human rights. For example, if giving the example that some countries are trying to reduce the greenhouse gas through increased reliance on biofuels. Although that is a good thing, but unfortunately that potentially impacting the right to food, or programs that support of reduce emissions from deforestation and degradation may provide inadequate protection for the right of certain indigenous peoples reliant on forests. So this is basically the disadvantages of this. Please, next slide. Human rights can usefully inform approaches to climate change in policy and legal matters, and that basically provide the dimension argument based on the human rights obligations of state under a variety of international law instruments. And the different states, they can get the help, and they can incorporate in their policies to mitigate the effects, to make more develop their adaptation policies regarding, and they can also incorporate that in their laws regarding this on priority entitlement to be protected from the impacts of the climate change. For example, the right to life, right to health, water and food, and more procedural human rights that are relevant to the design and implementation of policies that are relating to the climate change. Please, next slide.
Sana, if you can reach a conclusion soon so that we have time for 1 or 2 questions.
Okay, sure. Please share my conclusion and recommendation slides. That is 18. Okay, I will trying to conclude this presentation because there are some development regarding the climate change, and there is the approach that is a human rights based duty to reduce greenhouse gas emission, that is basically on the states that they will help and they will contribute to the induced process of global warming, how the states are allowed to do the business as usual with regard to their own national emission policies. And under international and national law, states are under obligation to protect and respect the secure the human rights from adverse effects of business activities. And the other reason is that there are some lack of administrative control or political conditions, fragile economic position of the developing countries is the major contribution in the environmental exploitations. So the only viable is better international cooperation and prioritizing the environmental issue. Therefore, it is important to take feasible steps or reasonable steps to protect the climate. In this regard, there is a dire need that the government and the states and the corporation, they should come forward to take steps in all sectors in order to conserve and protect the environment. And the recommendation, I would say that the states are the key player in protecting the human rights violation, and most importantly, the way of reducing greenhouse gas emission from industrial sector include using energy efficiently or switching to fuel options that are less harmful to the environment, and most importantly, efficient use and recycling of material. Thank you very much.
Thank you very much, Sana. Sorry for rushing you there.
No problem.
So we still have a few minutes for some questions, if we have questions. Okay, so I think that Joanna posted a comment in the chat for Sana, if you wanna have a read at that. Does anyone have questions they wanna ask to our presenters, to our participants? Or anything? I know that the people who are on site in Bogota will go for lunch very soon, but we still have a few minutes for some questions if anyone wants some extra information or discuss one of the points. Maybe I had a question for Joao, if you don't mind. Because I think someone mentioned, I think it was Joanna, who mentioned provision to obtain free, prior, and informed consent, or lack thereof. I think it was in the case of the Escazú agreement. Did you find any evidence in NCP decisions about any kind of applications of any kind of standards regarding stakeholder engagement that aims at obtaining that type of consent?
Yes, so I'm glad you brought this up indeed, because I did not have time to cover this in my presentation, and I did not particularly cover cases which bring up this point. But indeed, there are some cases from national contact points where it's clear that stakeholder engagement needs to follow a sort of higher standard that is aimed not only at taking the views into account, but also at obtaining their free, prior, and informed consent. These are cases that typically involve direct adverse impacts on indigenous communities. This is confirmed in several cases of the national contact points that we didn't cover here, such as the Aminikboko community versus Shell, which is a case from the Netherlands national contact point. You have also the case of the Starkeys versus Electra Net Pty Limited, and also a case about Project Sepik in Indonesia, I believe. These are all cases that sort of bring forward this importance of when corporations are conducting these projects and they are directly affecting indigenous communities, actually their stakeholder engagement needs to follow a sort of higher standard and needs to be aimed at obtaining their free, prior, and informed consent. But there are also other decisions, like the one, for example, of the International Federation for Human Rights versus Corriente Resources, where the national contact point actually says that free, prior, and informed consent is not a requirement set up in the guidelines themselves, and thus it does not technically apply to communities that are not indigenous or that are merely affected by the projects at stake. Thank you very much.
Thank you for this answer. And so I see that in the chat we have a question from Adriana Casas. And the question goes, is there an option to say no consent as a result of a FPIC? I'm not too sure who this question is directed.
I can give my 2 cents on that. Other ones can jump in after me if they want. I think that taking the standard of free, prior, informed consent as it should be, I would definitely say that this option of saying no needs to be present. I think what often happens in practice is that there is no legal agreement concerning what kind of threshold these communities need to. So, for example, if you have a community with 100 people, but 80 say no and 20 say yes, there is some kind of disagreement as to whether or not this would constitute a no. I mean, in democratic terms, it would constitute a no, but still, I think that that's where the legal debates are more placed at. But definitely, I would say that if a great majority of the community doesn't want a specific project happening in the vicinity of their locality, then definitely if the standards to be aimed at is one of free, prior, and informed consent, if a great majority of this community says no, then in my opinion, it will have to be a no, basically.
Okay, thank you very much. Does anyone want to add something on the topic of free, prior, and informed consent? Or I see that we're 2 minutes past the lunchtime already, so if we don't have any extra questions, I think we can close this very enlightening session and very international as well. I'll remind you that so after the lunch break, there's another panel at 2 o'clock in Colombia, so that would be in 2 hours, I guess, in Spanish. So another panel about configurar las democracias desde abajo en el antropoceno, that you can follow online as well if you want. Thank you very much to all of our participants for your input, and we'll see you next time, and buen provecho para los que están en Bogotá.
Thank you very much. Bye-bye.
All the best. Thank you. Bye.
Bye-bye.
Thank you. Bye.